Welcome to chapter 35 for BUL 3130. We're going to be looking over 35 this week. We'll do a lecture for 36 next week. Now, the quiz for these two chapters is not due until next week, so I just wanted to maybe try to get something a little bit shorter as far as the lecture went, instead of throwing an hour-long lecture at you again like we had with chapters 33 and 34. All right, so getting into this, we're kind of picking up some of what we left off with last week. We'll talk about a couple of the principles that we discussed last week. And in doing so, we'll tie that into how the management structure for these corporations are done. Last week, we brought you into the mindset of thinking about closely held and publicly held corporations. When we talk about the management structure this week, we'll discuss the management structure in both of those types of corporations. That will lead us to a better understanding of how each one of these works and operates, and how some of their structure is dictated by the amount of ownership that they have, the number of owners that have stake in one of these corporations. All right, so let's get into it. First thing we're going to talk about is corporate governance. And when we talk about the corporate governance, we'll talk about the role of shareholders. All right, their voting rights, their enforcement rights. And then we're going to go into the roles of directors and officers. Now, we'll spend more time talking about these roles because they're the ones that owe such a duty to the corporation and to those shareholders that we talk about with their rights, and how the duties that these officers and directors have tie into the rights of these shareholders. All right, so the management structure in a corporate setting, it's going to be set up however the state decides that it should be, depending upon where they incorporate. That state will have a design structure for how the corporation will work. We'll see in a couple of these slides that it's either in a pyramid or an inverted pyramid, how the power works down or up, depending on how you look at it, within these corporations. And the first one we're going to start off with is the one that looks at what the statutory model for a corporation is and how that works. With this, you have the largest area is going to be your shareholders. Their jobs, as we talked about last week, are the election of these directors, the removal of directors, approve fundamental changes, something we'll talk about in chapter 36, the fundamental changes that happen within a corporation. We'll also talk about these board of directors, the things that they do, declaration of dividends. We talked about disbursements last week. That's one of the things that the board of directors do, how they delegate the authority to the officers. We worked on trying to explain that last week, the management of the business of the corporation and how they have to do their decision making. And then the officers that take care of the day-to-day running of the corporation. The officers, remember, are any of those that have a C and an O normally in their name. They're chief officers of some part of the corporation. It may be a chief executive officer, a chief information officer, a chief financial officer, and all those would be in order of the CEO, a CIO, and a CFO. All right, so that is how those work together. When we discuss what corporate governance is, of course, it's that statutory model. It's set up by the state, whatever that statute, how it decides it's going to be. A great majority of corporations are closely held, a small number of stockholders. They're not ready for the market. They do not sell their shares on any of the stock markets. They hold it within a small group. Typically, those shareholders also will be the directors and officers. If you think of your smaller corporations that have reached the point where they want to be a corporation, they have incorporated, but their setup is not going to be such that they have a vast employment base. They do not have a vast board of directors that comes from all different walks of life. It's normally going to be those who started the corporation. In a corporation that starts when it's just three or four people that have decided to form this corporation, you may have the one who is uh, the head or the board on the board of directors, the one who is the chair of the board. They may also be the CEO, or they could be, depending upon what their expertise is, they could fit into one of those other officer spots. That is in a closely held. When we get to the publicly held corporations, it's going to be a lot different. That setup is vastly different because we have a group of owners who have elected a board. That board then, in turns, by mandate of what the owners say, they hire in officers to run the corporation in the way that the management or the ownership has said they want it to run. So the ownership, those shareholders in a publicly held, state how they desire for this corporation to be ran. They elect these directors to carry out that mandate in hiring and decisions they make. All right, so that's the difference between the two. You have a larger group with a larger voice of and a larger group of opinions that come together to work within these corporations. In a closely held, the shareholders will equal normally the directors and the officers. In a publicly held, it works a little different. You go the shareholders being that largest part at the top, working their way down to the officers and how their jobs work. Let's talk about what the shareholders do. So, in a uh, corporation that is, and let's go ahead and just name like a Walmart or a Target, something that is publicly held, or an Apple or Amazon, any of those, the shareholders carry rights. Part of their rights are voting rights. So they can have shareholder meetings. Shareholder meetings are where they come together to vote on things that are going on. They do these in annual meetings at least. In every corporation, they have to have an annual shareholders meeting. Plus, there may be a need for special shareholder meetings to address certain things going on within a corporation. Maybe the corporation is not doing well. They need to address some things there. Or maybe there is a group of shareholders that call for a special meeting to change something on the board. Recently, within the past couple of years, Disney has had some activist investors who were trying to get positions on the board of directors with Disney. The shareholders came together because of a called shareholder meeting. They came together, voted, and each time they denied those activist shareholders the ability to have seats on the board. The majority of the shareholders did not agree with the direction that uh, those investors, those activist investors, those activist shareholders were wanting to take the corporation. And so they voted against them and they did not get their seats on the board. Sometimes that works in favor of the ones who are calling that special meeting. They may get voted a seat on the board, and that gives them even more power because now they have a say in what is being brought up before it even makes it to the shareholders. That gives them the opportunity to look closer at the day-to-days and how things run. When they have the shareholder meetings, they have to have what is considered a quorum. Anyone who's ever done anything, maybe it's in different clubs you've been in, maybe you've been in a position where you were an official of some sort. You were in a spot where you did elections, and you understand that a quorum means that you have to have a certain number necessary for it to be a valid vote, for it to be a valid meeting. You cannot transact business without the quorum being present. Normally, that is something that is recognized by the chair and brought up by someone that there is a quorum present, normally someone who is keeping the minutes or keeping track of those things, timekeeper or a parliamentarian, whatever may be there. They will be the ones to recognize that a quorum is present, bring it to the chair's attention so the chair can bring the meeting into order, and they begin talking about business that is going to go on and talk about what needs to be voted on. the different types of voting that can be done. When we think about what election of officers or election of directors are, I, pardon me, you have straight voting. That's where directors are elected by a plurality of the votes. Then you have cumulative voting. So shareholders can multiply the number of votes they are entitled to cast by the number of directors for whom they are entitled to vote, and to cast the product for a single candidate or distribute the product among two or more candidates. So they can multiply that by the number of directors that they're entitled to vote for. If they have 5 shares and that gives them 5 votes, if they're voting in the case like a cumulative, if they're voting on 5 officers, they end up with 25 votes. They can throw all those behind one officer or split the 25 up among a group, depending upon how they decide to vote. But some of the other things they do with votes are the removal of directors. A majority of the shareholders will have to vote to remove a director, with or without cause. Normally, that would be subject to some type of cumulative voting rights, approval of any fundamental changes. This is something we'll discuss in detail next week, but the approval of fundamental changes is something that has to be done by a majority of the shareholders. Has to be approved. A fundamental change cannot take place without the shareholders voting on it and agreeing to it, allowing it to pass. The concentration of voting power, it can be done in a few different ways. You can vote by proxy, which is when you give someone else your vote, tell them to vote in a certain way. You authorize them to vote your share in a way. You would do this with someone you agree with, not with someone that is going to vote opposite of you, because once you give them that power, they have it for that vote. So you want to make sure that it's someone that you trust to vote your conscience and vote the way that you ask them to do. Voting trusts are sometimes used, and that's where the transfer of the shares, voting rights go to one person who acts as a trustee. In a day and age where we have shareholders spread out across the world in a lot of these corporations, things like voting by proxy, things like voting through a trustee, can become very handy when you have a group together that want to vote a certain way. Sometimes you have groups that own those shares, and they have a trustee that they work with that will do the voting. It may not be specifically owned. You may have 5,000 shares. They're not owned by one person. They're owned by a group that have came together to buy that interest and invest their money as a group. They will vote based upon a trustee, normally someone who is over that, who handles those shares, the manager of those shares, and they'll vote for the group. The voter agreements, they provide shareholders with greater control over the election and removal of directors and other matters. I notice that nowhere in there is the firing of executives, the hiring of executives. That is only under the purview of these directors. That's why it's so important for the directors to be subject to your shareholders, because the shareholders have nothing to do with hiring, firing. In other words, managing that corporation. They do not handle that part. Why do we do that? That line that draws that limited liability out for these shareholders will real quick begin to bend and break if we have shareholders imposing their will upon who is running a corporation, imposing their will over who's being hired to run a corporation. It is important that it is solely the directors, the board of directors, who handles these type of decisions. We do not want the shareholders making these decisions. Now, do they use a word on the screen? Do they by proxy? Yes, they do to a certain extent, but that is something that uh, is allowable because that's what the job of those directors are. And I'm going to do something real quick that I just realized was not done. The voting, all right. The restrictions on transfers of shares, there must be a reasonable and conspicuously noted. For someone to vote your share, there has to be an acknowledgement made that this is okay for that vote to count. There has to be something in place that states that this person can vote for you or this individual can vote for a group. A chart that kind of builds on how the votes work. Proxies, what a proxy is, what a voting trust is, what a shareholder agreement is. I won't spend a lot of time going over that to keep this as brief as possible. You can kind of go over it. It gives you some time frames there, how it works, if it can be revoked at any point, how prevalent it is in the different types of corporations that we discuss. So spend some time looking at it. There's I know a couple of questions on this that have to deal with the duration and the revocability of these types of different voting powers. So make sure that you're paying attention to those. Now we get to the rights of the shareholders as far as how they're enforced. The shareholders have that same uh, ability that we talked about with other owners. Keep in mind, shareholders are the owners of these corporations. So they have the same ability that we talked about with owners when it came to or members in an LLC. The owners or the partners in a partnership, they have the same control and the same ability to inspect the books and records. They have to do so in good faith and for a proper purpose. A good faith is that they're doing it for a reason that is not detrimental to the corporation. The proper purpose would be for reasons of a vote, reasons of suspected uh, wrongdoing by someone, those type of things. They cannot be for personal gain. They are specifically for the betterment of the corporation. If a shareholder brings a suit, it's the same way. A direct suit is brought by the shareholder of a class of shareholders against the corporation based upon ownership of shares. That would be one that they bring it against the corporation because there's something going on that is has happened to be detrimental to the shareholders or watching out for the ownership. A derivative suit, on the other hand, is brought by the shareholders on behalf of the corporation to enforce a right belonging to the corporation. The difference being direct suits are ones where the shareholders may receive some form of compensation in the suit. A derivative suit, the shareholders do not receive compensation, but the corporation does receive whatever is being sought in the suit. So whatever they're looking to get out of that suit, that lawsuit, these are going to be civil actions, of course, and whatever they're looking to get in that tort that they're bringing that has happened, that will normally go to the corporation. It doesn't go to those shareholders, no matter uh, if it's one bringing the suit, a group that's bringing the suit, it still goes to the corporation, which eventually will trickle back to those shareholders. Shareholders have a right to dissent. They can do so because of certain corporate actions. They cannot agree to a dissent. Real simple is just not agree. They cannot agree to an action that's done that requires shareholder approval. Now, if the shareholders as a whole do not agree to it, then it would be something that could not be done, and the board, in that sense, would have to go back and begin to rebuild it. The board really is, and when we think about the rights of these shareholders and how things work, the board really is that go-between for the management of that corporation and the ownership of that corporation, because the board is going to see things that management's trying to do they think need to be voted on when they bring it to the shareholders. Shareholders will either agree or dissent, and then it'll go back and be something that they implement or something that they have to go back and start over on and fix whatever was the reason for it not passing. Just another chart on shareholder suits and how they work. And then we get to the directors and officers. We'll talk first about the directors because they are that in between. They're the intermediaries between the ownership and the management. The directors, and a quick note about the board of directors. Board of directors do not necessarily have expertise over the corporation they're running or they're the board of. A few years ago, Starbucks, and I'm sure they have a similar setup now, as do a lot of corporations. They had Starbucks on their board at one time. They had someone who was an executive in the car industry, the automotive industry. an executive in retail. They had some people who had held public office that were sitting on their board. They were not necessarily people from the uh, coffee industry or even from hospitality in that sense. They were from different areas, but what they brought was a different area of a different type of expertise to the board. It's important for the board to have a broad area of expertise. Why? Because that's contacts that they have in other industries. That is ways that were successful in other industries. A lot of times, if someone's elected to a board, they were successful in the industry they were in, and that's the reason they get those seats, and they're allowed to do that under the approval of the ownership because they were successful at some point. Their job is the selection and removal of officers. They hire and fire the CEOs, the CFOs, the CIOs. They hire and fire those folks. They bring them in, search based upon what the direction of the corporation is going to be by the ownership. They make sure they can complete that agenda by bringing in the right folks. They're in charge of the capital structure of how the corporation is set up. Any fundamental changes, they are the ones who come up with those. They will vote on it prior to it going to the shareholders. When they have the power to make, amend, or repeal bylaws unless the power is given exclusively to the shareholders. The directors declare disbursements or a dividend, the amount and type of dividend that's going to go out. They will declare that. Remember last week we talked about that. That is something once they declare it, it becomes a contract with the ownership that has to be paid by law. And then they handle management compensation, setting up those compensation packages. It's important to think about that as far as they're supposed to be that intermediary that goes in between. Some of those compensation packages really don't sound like they're looking out for the ownership when you consider how big they are. Take, for instance, the one, and I hate to harp on Elon, but the one that Elon Musk had that was declared as inappropriate or not legal, or however you want to look at, by the state of Delaware when the shareholder sued. That was a shareholder suit on behalf of the corporation, a derivative suit on behalf of the corporation, concerning the compensation package that Elon Musk had been given by the board of Tesla. And they found it to be something that was not on the up and up. And they had to go back and look at it again. And of course, they're restructuring it, and they'll give him the same amount of money. It'll just be in different forms and different ways. It just will not be something that will be as easily seen in that way. The election and tenure of the directors, they're elected. The number and how long they're going to be there is set up by the incorporation statute, or the articles of incorporation and the bylaws. Some state statutes will have a number of directors that have to be present, depending upon the size and number of shareholders of a corporation. Others will say that a corporation that handles X number of dollars will need to have, a set number of, or a minimum number of directors. How long they're going to be in that position, some maybe by statute, a lot of that the bylaws handle. A lot of directors will be for several years, to where the chair of the chair of the board of directors may only be for a set period of time, smaller than the actual time frame they can be on the board. If there's any vacancies or directors need to be removed, they can be filled by a majority of the remaining directors. That can be done by a vote of the remaining directors, as long as a majority of them voted in. Now, notice this part: their compensation is set by them. Okay, so this is one of the times they get to set their own compensation. It is something that is closely watched. There are certain rules that apply. And of course, if the shareholders saw that it was something that is being done in overboard, they can always sue and bring it to court. They have the power to bind the corporation only when acting as a board. Notice that the directors have to be acting together, working together as a group, before they can bind the corporation into a legally binding contract or any type of agreement in that sense. Minimum number of members are required to be present. They have to have a quorum, and that's going to be set by the articles of incorporation or by the bylaws. Normally, at least, a lot of them, they want at least half plus one, whatever that may be. So there's not, if there's any chance of being a split vote, there's always that one extra one there to vote. That normally is the half plus the chair. The chair would normally be present for anything that goes on like that anyway. If there's an action that's taken without a meeting, there has to be consent in writing signed by all the directors for there to be something that happens without a meeting prior to that action being taken. They have a delegation of, they can delegate their powers into committees uh, to perform some but not all of the board's function. They can't just put everything off on committee. Some things have to be handled as a board as a whole. And then the directors' inspection rights, they have the right to inspect corporate books and records, the same as shareholders. Once again, it has to be for the right reason and for done in the right manner. The officers, when we look at the officers have they can usually their removal is controlled by the board. We already talked about that. Their role is going to be set by the bylaws. They're agents and fiduciaries of a corporation. That's very important. That's the first time we've seen that word in this PowerPoint. But they're fiduciaries of the corporation. They owe a duty of care and loyalty to the corporation. By that, they also owe it to the shareholders. Their authority of the officers is set by the bylaws also. They can bring the corporation into binding contracts. They can bind the corporation. They can be express or implied or apparent, depending upon their office. The chief executive would be considered as the one who runs the corporation and have there'll be express powers that they have or authority. Some of it will be implied by their title, and some will be apparent just because they are the chief executive. The duties that they have for both of those, they have a duty of obedience, and this applies to directors and officers. So with both groups we just talked about, they act within their respected authority. Okay, so whatever their authority is given by the statute, given by the articles of incorporation, given by the bylaws, given by the shareholders, they act within that. They have the duty of diligence. They have to do their due diligence in anything they do for the corporation. That due diligence is they exercise the ordinary care and prudence that it takes to make informed decisions. A duty of loyalty, non-deviating loyalty to the corporation. They do not do anything for their own benefit that can harm the corporation. If they're involved in other businesses or anything along those lines, they are not in direct competition. They do not take away business from the corporation. They do not enter into any agreements that could harm the corporation on their own behalf. Those are some of the duties of loyalty that exist there. I think we have one more slide, maybe two. The business judgment rule applies to directors and officers. This precludes imposing liability on directors and officers for honest mistakes. It gives them the ability to make a mistake if it is an honest mistake, and these things have to be in place for that to kick in for them. They acted with due care, in good faith, and in a manner reasonably believed to be in the best interest of the corporation. So they had to have done these things: the duty of obedience, the diligence, and loyalty. They had to have done that and been acting within those. And they were making a judgment based upon everything they saw, and everything looked that way. It's easy for these type of mistakes to happen. Why? There's some protection there. A lot of corporations invest. They invest in other corporations. They buy businesses. They sell businesses. They do a lot of things, and most of those are for the reason of making money, bringing in capital. Remember, we talked about the financial structure, that capital they have to bring in. So in some way, they're trying to raise capital. Every once in a while, you make a mistake. We all do. all of us have bought something that we shouldn't have bought, even though we thought we did all the research we needed to do for it. Uh, they're protecting that. They also have indemnification. Uh, the corporation may indemnify a director or an officer for liability incurred if they acted in good faith and they were not adjudged negligent or liable for the misconduct. There was not any adjudication that says they were liable for it. And then liability limitation statutes. States will now authorize corporations with shareholder approval to limit or eliminate liability of directors for some breaches of duty. It's a way to protect the directors when things may be done that were not expressly designed to cause harm. All these are in place not to protect somebody to go out and do whatever they want to do, but to be there in case there's some accidental harm that comes about. All right. So that brings us to the end of that one. And like I said, I just wanted to do a quick do this chapter this week, 30, 35 this week, 36 next week. I wanted to do that so that they were split up. You didn't have to sit for quite as long. If you have any questions on any of it after you watch the video, please reach out to me. Remember, the quiz for this is not going to be due until next week. This week you have that discussion about your ethics and stuff that is there where you're looking to build that. So make sure that you're doing that, getting that discussion done. Put some good replies in there. Make sure you're putting your good effort in it, following the instructions, looking at everything that is set up for that. All right, so until the next video, and that next one will be the last one that I do for any new information until we get ready for the Zoom meeting, and I will be sending that out probably this week. I'll be sending out the invite for that Zoom meeting, which will be likely the Monday after Thanksgiving. So if you watch this and you have a reason that you can't attend that, go ahead and let me know. And we can see what we can do. But I like to get those done at least at some point prior to the final opening. That likely is a Monday or a Wednesday is going to be the limit that we have there because it'll open. I believe we'll have the final set to open that Friday, going into the weekend and carrying over as we wind up the term. We're almost through it, y'all. We've almost made it there. Almost time for that long break. All right, you'll get that long break before you come back for classes. Some of you will be graduating and getting ready to go do something with this degree that you've spent these last 4 years working on or more. All right, so until the next video, y'all stay safe and study hard.